Blog Talk Radio.
Welcome to Solutions with Courtney Anderson. I am your host, Courtney Anderson. And today we have a part two to a two-part episode. And this is part of our Law Lovers Lounge series. Of course, our Law Lovers Lounge series is where we specifically focus on issues that are legal. And as we love the law, obviously that's why we're law lovers, we are enthusiastic and excited, and we're ready to find out what we need to know to accomplish our goals and to surpass our goals. It's a lounge because we're relaxed, we're happy, we're feeling good. One of the most exciting things in life is to be able to talk about law. And finally, here is a place where we can do so joyfully. So we're in our Law Lovers Lounge, and again, just my little disclaimers have to make. I am an attorney, licensed in Texas for profit, and then I provide pro bono, which is free, no-cost services in Nevada. I am not your lawyer. I am providing this as an educational service to the public, and so I just have to be clear because sometimes there are issues where people misunderstand and think that I'm their lawyer when they have not signed a contract and they are not a client of my law firm. So Courtney Anderson, CourtneyAnderson.com, you can always come to just for general information about the show. If you have specific legal issues and you'd like more information about my law office, that's located at litigationmitigation.com. Our topic, part two of a two-part episode is, I think that I'm about to be fired. What should I do? So this is an issue where someone believes they're about to be fired and they want to know, what should they do? In episode one of this two-part show, we talked a lot about whether or not somebody actually can be fired. In other words, just because you're doing, quote, work doesn't mean somebody has a legal right to fire you. You have to be an employee, technically, for what we generally think of being fired and there being some sort of legal problem. If I'm not an employee, I can't really be fired. And we talked about the difference between someone who's an employee, right? And we talked about the fact that in the U.S., the federal government has an entity called the IRS, the Internal Revenue Service. Their job, and what it sounds like, is to collect revenue internally, which is another nice way of talking about taxes. And they have created some guidelines to help us all figure out, am I an employee or not? If I control the means and the methods of doing a job, I'm more likely not an employee. So if I go to do a job, right, to get paid for a job, for work, but I control what time I do it, how long it takes, what I wear, what steps I take, what I say. I pay for my own equipment and tools and uniform. I pay for my own computer and cell phone and everything. I mean, I'm paid for it, and I'm in control of when I do it and how long I do it, and if I need to take a break or go to the bathroom or whatever. I control that. More likely, I'm a contractor. I'm working either for myself, which would be an independent contractor, or I'm a contractor, meaning I work for some other entity. So I work somewhere else, and then that place has provided my service on site to a client of theirs. Most commonly, you think about something like a temporary agency. So a lot of people think about a temporary agency. Temporary agencies are big; they're all over the world. A temporary agency in the U.S., you apply to the temporary agency. The temporary agency hires you, right, as their employee, but you don't work at their location. They hire you to work for them, and then they send you out to all these different client sites to go do work for their client as a temp. So you're temporary at that location because you don't work there. The temporary agency is your employer. They're the ones that give you your paycheck, any potential benefits, but then their whole business model is to take the people that work for them and then sort of loan them out as temporary contractors to other organizations, okay? We see that? See the difference? Independent contractor, work for myself. Contractor, I work for some other entity as an employee, but I don't work for the place that I'm delivering services, right? We see that? Like a temporary agency type situation. And then the last category, which is finally the one we needed to talk about, was I'm an employee of this place right here. I'm an employee of the place that I think is about to fire me. That's where we have a legal potential discussion. So I'm an employee. I work for the company that I'm currently providing services for, okay? And I am concerned. I'm about to be fired. In episode 1, we talked about the concept that being an employee is a big deal. Being an employee is exciting and awesome on both sides of the equation. So if you're the employer, there's a lot of wonderful benefits that come along with it. And if you're the employee, same situation. But there are also responsibilities and nuances that a lot of people don't fully understand. Being an employee and choosing to enter into an employer-employee relationship is in some ways broadly analogous or similar to entering into a marriage, entering into a legal marriage. So, a lot of people will say, I'm getting married. It's just a piece of paper. Not really. There's a lot that happens when you legally get married, and we're doing a show on that here coming up. And everything from your rights to financial issues, your rights to if something happens, if you're injured or you die. There are so many rights and responsibilities that kind of come along as part of the package deal when we get married that we really need to be aware of that, because when we're not aware of it, sometimes it leads to negative outcomes and to sometimes some emotional and financial pain. We don't want that to happen. So it's sort of like that getting into an employer-employee relationship. Some people just say, I need a job, whatever, I don't really care, I'll just sign whatever. Oh, okay, you're going to hire me? Great, I'm here, hire me. And they focus on things that really shouldn't be the number one issue. They focus on, how much am I going to get paid? Is it every other week? Is it once a month? Is it every week? That's important, but you really need to understand what the rules are and all these legal things that kick in when you decide to enter into voluntarily an employer-employee relationship. I mentioned the concept in episode 1 of respondeat superior, right? That's Latin, and that's a concept, a legal idea from England historically, which is where the U.S. Has a large amount of their laws that are derived from, which makes sense as they were a colony. And the idea of respondeat superior, remember, it's Latin, but it means generally the master answer. Let the master answer. Ooh, what's that? As we previously shared, the master is the employer, and the whole idea, this is called the master-servant rule. Your master is your employer, so your employer has to answer or is responsible for everything that their employee, historically called their servant, does while they're working or while they're in what's called the scope of employment. So this is a big deal. If somebody decides to be an employer and they enter into these relationships with other people as employees, then anything the employee does, the employer is responsible if they were in the scope of employment, meaning they were working, during that period. So if they have an employee, the employee is in the company car, they're supposed to be making a delivery for the business, they go out and they are not paying attention and they run over another vehicle in front of them, then the employer has to pay for that. They're going to be liable. That's a big deal. And it extends to basically everything you can think of. So the employee does it, the employer's on the hook for it. They have to answer for it, and that's a big deal. On the other side of the equation, the employer, we talked about, remember, we said it's sort of amazing how legally important this is. The employer has a lot of awesome benefits. An employer can literally do all of the following in the U.S. The employer can tell you what time you need to be somewhere. They can say to you, you need to be at this desk in this building at this location at 8:30 a.m. Monday through Friday. You need to wear this uniform and this name tag. You are going to sit at this location until it is time for your 15-minute bathroom break. After your 15-minute bathroom break, which we will tell you when it starts and obviously when it ends, you have to come right back to this desk and continue to sit here, and you have to wear the outfit, and you have to say exactly what we tell you to say. In fact, many employers actually have scripts where if someone is going to talk to a client on the phone, then they have something they have to read. And if they don't read exactly what they're supposed to read, the employer's listening to them while they're talking, and we'll document this and provide a negative consequence and say, look, we told you to sit in this place, to only leave to go to the bathroom and to have lunch when we tell you, for the amount of time that we tell you. We told you that if you're going to talk, you have to say exactly what we say. We tell you to say, and you can't change any of this. If you do, then you're in violation of their policies, and they can have a negative consequence. So that's a lot of power over another person to tell you what time to be somewhere, how long to stay physically in a space, whether you can sit or stand, whether you have to smile. I had the awesome privilege of supporting myself financially independently since I was a teenager, about 17. And it's been wonderful. Early in my life, I had the opportunity to work in a variety of employee situations. I worked in the fast food industry at many of the world's leading fast food brands, especially in the pizza industry. I did a lot in the pizza services, fast food, pizza delivery, pizza cook, things of this nature. I worked in retail. I worked in shopping malls and retail, large retail brands. I've worked as an administrative assistant. Or secretary, sometimes they're called. I have done so many jobs. I worked in what was a big business at the time when I was younger, telemarketing. And that's where you go and you sit in a certain place at a certain time, and then a computer pops up and you read a script. And I worked for some large financial institutions where I would call people at their houses while they were eating dinner. And I would try to get them to sign up for a credit card. And some of the people were really happy that I just sort of was randomly calling them out of the blue. Some people, I'd say the majority, were not so happy to hear from me as a telemarketer calling them to offer them this super awesome potential credit card. But that's what I did. So I've done all these different things, and many of them were minimum wage. Which the minimum wage is the law that says here's the lowest amount of money that you can pay somebody, the absolute bare minimum. And so done all those jobs. And I've been an employee. And in situations like these, I had a name tag I had to wear. I had a uniform. I had a certain hat I had to wear. I had requirements of how long I had to sit in my area and when I go to the bathroom, when I could take a break, and what I could say, and all this kind of stuff. It's a lot of control. And it needs to be. We just said that this whole thing about responding at superior, the employer is responsible, so that means they have to set up all these requirements to try to make sure that they know what's going on, because they're going to be responsible for whatever somebody does. So there's a lot of power to it on the opportunity for the employer. But why would an employee agree to this? What's in it for the employee? Well, the employee gets the opportunity to not have to worry about any of the means or the methods or the tools for the job. So the employee is not finding office space. You're not worried about paying the rent. You're not worried about the electric bill, about the water bill. You're not worried about paying for the computer, paying for the phone bill. None of this is your worry. That's all on the employer. All you have to do is literally just show up, sit where they tell you, use their computer, talk on their phone. They're paying for all of this. And then all the money they give you is totally your wage. None of that is related to the business expenses. You don't have to pay anything out of it. It's just purely for you. That's totally different from if you're a contractor, especially if you're an independent contractor. Independent contractors, I gave the example in episode 1, like a plumber. Right, so you're at your place where you live, and the sink is clogged up. I need a plumber. You call a plumber. The plumber comes over. If they're an independent contractor, right, and they work for themselves, they bring all their own tools. They don't come to your house and you have to go provide them with their plumbing tool. No, they show up with all that stuff, right? They have all their stuff to unclog the plug. They have their own control over how long it takes. They have their own control about what they charge. They have their own control about all of this. They need to stop in the middle of their work. It takes a long time and go take a break or whatever. They can do all that. You can't tell them what to do. They control the means and the method. But they're also responsible for paying for all of this, right? Paying for the tools, paying for their vehicle to get to your location as a client, paying for everything. Right? Marketing, paying the taxes and paying into federal systems are their attendants. They have all the burden themselves. There's nothing like an employee in the U.S. has shares. The employer has to make sure that all the federal systems are paid into, like Social Security, And it's just a totally different world. So the employee, to a certain extent, has the freedom of not worrying about any of that. They're not worried about the bills for the business at all. They're not worried about anything. Just show me the part you want me to do, and I'll show up and I'll do that and I'll leave. And I'm not worried about anything else. And so both sides benefit, ideally, if it got done the right way. So we did a lot of that to clarify, am I an employee? It's very important that we understand the picture in the U.S. that there's different types of employees. Okay. One type of employee in the U.S. is called an employee at will. And what that means is that they're subject to this law called employment at will. Employment at will is one of my favorite laws to teach because it's incredibly simple and short. Basically, it works like this. If you are an employee at will, your employer can fire you at any time with or without notice or cause. And you, the employee, can quit your job at any time with or without notice or cause. So the employee who's at will can literally be sitting in the middle of their workday and think, you know what, I am sick of this. This is not the career for me. I am tired of this chair. I don't like the way the building smells, and I'm done. I am leaving like right this second, and I don't care what they said about when it's break time or anything. I'm going to stand up right now, and I'm out of here. I'm leaving. And they can. The employee at will can say, hey, take this job and shove it. I'm out of here. Because the law says you can quit at any time, with or without notice. That means you're not giving them notice. You're not saying anything other than, hey, I'm outie, bye. You don't even have to say that. You just pick up your stuff and walk out. You don't have to say anything. No notice. You don't have to give them any cause. You don't have to say to them, oh, I'm quitting because the commute's too long or it doesn't fit with my, family schedule or anything. You don't have to tell them anything. You are free to come and go and do what you want. The other side of the equation is the same, though. The employer is free to tell you goodbye, right? You can tell them goodbye at any time with or without notice or cause, but they can tell you goodbye at any time with or without notice or cause. Now, there are two big groups. Okay, so we're only talking about employees, right? We fixed all of that. We cleared up. You're an employee. So you do not control all the means and the methods of the job. The place where you work, they do. So you're an employee. You have two big categories if you're an employee. You're either at will. In the United States, the overwhelming majority of people in the U.S. are at will employees. And again, I just explained the law. It's easy. They can tell you to go at any time, with or without notice or cause. You can tell them you're going at any time, with or without notice or cause. Nobody has to say anything to anybody, right? You go. You go, they tell you to go. That's pretty simple. That's group one. You're an employee at will. There's only one other big general group. If you're an employee and you're not an employee at will, it's because you have an employment contract. An employment contract is sort of what it sounds like. It's literally a contract, like any type of contract. So imagine something in writing, ideally. I'm not going to go into the details at this minute about whether or not it has to be in writing. If it's for more than a year, in my jurisdiction in Texas under something called the statute of frauds, it does have to be in writing. But that's neither here nor there. Imagine a contract. Any type of contract. A contract is an agreement. Who's going to do what, right? It's an agreement to perform. So I have an employment contract. How do I know if I'm at will or have a contract? Well, you either literally have an individual contract that they gave you when you started working that you negotiated. How much am I going to be paid? How much money am I going to get if something goes wrong? Typically, you are going to be a very highly skilled and specialized employee, like you are the vice president of the entire company. You're the president of the company. You're the COO. You're the CFO. Those people usually have contracts, individual contracts that basically lay out all these, contingencies. If it's a disaster and the stock price is horrible and I'm, going to be terminated, then you're going to have to pay me X amount of dollars as sort of my goodbye gift, right? Whenever you read in the media about executives, getting the boot basically at organizations, but yet they leave with these huge packages, right? And either cash or stock or both, it's because they negotiate all that up front. It's sort of like the difference between entering into a marriage with a prenuptial agreement, which is a contract where both parties sort of lay out what's going to happen if things go wrong. It's a contract. And then the majority of people who don't have contracts in marriages, they just sort of jump on in there, and then you're just going to have to follow your default rules. And they're going to be really different than what you could have negotiated on your own in a prenuptial. It's the same thing here. As an employee, if you're at will, then I just told you what the law is. It's that simple, basically. You could quit at any time without notice or cause. They can't tell you you can't leave. That's ridiculous. Your legal right is to leave whenever you want to. Now, there's consequences to that. And they can tell you to go. If you are not at will, it's because you have a contract. You literally have an individual contract you sign with them. And either it's because you have a senior level of responsibility, or sometimes you'll see it with really uniquely skilled people. I mean, their skills are so special that there are so few people in the world that do what they do that they can individually negotiate a contract. So sometimes you'll see people with, they're artisans, or there's specific types of creative talents, or there's specific types of athletic talent sometimes. You'll just see this, and they'll have individual contracts. Because their skills are so rare, it's hard to find somebody like that, and they can dictate their own prices and their own terms, and so they sign contracts. And employers sign those contracts because they need that talent, and they know they can't get it easily somewhere else. The other group that has contracts are people who have gotten together as a group, right? So they couldn't individually get a contract because either they weren't specially skilled enough, they weren't high level enough in an organization, so they got together collectively, and they bargained as a big, huge group for a contract. That is what we call a union. So you'll see that, and that's where a whole bunch of people will get together. So right now I'm based in Las Vegas, Nevada, where there's a strong union presence, especially among people who typically don't have power to get individual contracts. People who work at big resorts, hotel, casinos, maybe people who are part of the janitorial service or clean your hotel room, people who are servers at a restaurant. But there's collective bargaining. So all those people, the whole group of them gets together and forms one big unit and says, all of us that clean hotel rooms at this organization with this employer are negotiating these terms. And then they sign contracts that describe all kinds of stuff and give them all these different rules and protections and rights and payouts and benefits and everything, but it's in the contract. So if you're working in the U.S., you're either at will or you have a contract. The overwhelming majority of people are at will. If you have a contract, it's either individual or collectively as a group, people have negotiated contracts. And that's it. Here you are. You're worried that you're about to be fired. We spend a lot of time going over, are you eligible to be fired? Because if you're not an employee, you're not being fired. They're just saying, we don't want to work with you anymore. If I don't hire the plumber to come back to my house again, they fire them. I just decide I don't want to use their service. See the difference? There's a legal liability to me not hiring that plumber again, or going to that hair salon again, or using that dry cleaner again. You see the difference? Okay. So when we're looking at this concept of I'm about to be fired, what should I do? You are an employee. I hope that you understood that discussion about at will, because it works like this. If you're at will, which the majority of people in the U.S. are, you basically have very few rights. Because the rule is simple. You can leave. They can tell you to go. Now, there are a couple of things that they cannot tell you to go, meaning they can't fire you because of. And the federal government in the U.S. has a very relatively, compared to other countries, a pretty short list of things that they are not allowed to fire you or to make any other job decision. So they can't, refuse to give you a promotion. They can't reassign you. No job decision can be made based on the fact that somebody's in what they call protected classes. So they can't make a job decision based on your race, your color, your gender, national origin, religion, your age if you're over 40, your status as a veteran, whether or not you served in the military, if you have a disability, if you are pregnant or might become pregnant. So there's a pretty short list. These are federal laws that protect everybody everywhere in the U.S., whole separate shows explaining how all that works. But in general, if you think you're about to be fired, and it's not that they're firing you because of your religion, it's not because they're firing you because you're over 40, and it's not that they're firing you because of your disability, but they're firing you because you were late. They're firing you because you didn't follow their rules. They're firing you because you didn't read the script like they told you. They're firing you because you didn't wear your uniform like you're supposed to. You kind of out of luck, and I'm just going to be bluntly honest. A good lawyer can listen to your situation and see what's going on and see if there's any potential move and room to potentially see if you have a legal claim. But if you're at will and the company did a good job meaning employers are supposed to do this. They're supposed to document why they do things, not because they have to. Remember, at will says they can let you go with or without notice or cause. But it is helpful to them if they took the time to figure out, hey, we did document why we let this person go, and here's the paperwork showing that it was all about their performance. And that's what performance reviews are about. I mentioned in episode 1 that the warning signs that you really are about to be fired, it's not your imagination, are you're on a performance improvement plan, which is where the employer sits down and is documenting all the things you're failing to do that they told you to do. The reason they're doing this, ostensibly, it's because they want the employer to have a chance to kind of get it together and improve. And sometimes that does happen. It's just rare. Usually by the time you're on a performance improvement plan, you're on the way out the door. And they're just giving you this, 60 days or 90 days or whatever, and telling you all the things in your improvement plan that you would have to change to help them prove and document when they tell you to go that, hey, we gave you a chance. We told you what you were doing wrong. We documented it. We gave you another, 60 days or 180 days or however much time they want to give you in the performance improvement plan. You still didn't do what we said that you were supposed to do to our satisfaction, and you're gone. And they're just documenting. All they're doing is building documentation to show that, look, you're an employee at will, and they're not letting you go from one of these laws that they're not allowed to, make decisions on, like your color or religion or gender or anything of that nature. They're letting you go for your performance. And that's what they're doing, is just getting their paperwork together to prevent you from, if you do get fired, being able to bring a viable legal case. That's what they're doing. I'll mention, if you have a contract and you think you're about to be fired, you're not stressed out. You're not asking, what should I do? Because you have a written contract that tells you exactly how it's going to work. These contracts are incredibly detailed. And they'll tell you what happens if you're terminated. They'll tell you how much notice you have to get, what your financial options are going to be. I mean, it's all laid out, so you're not worried. Those people aren't going to lawyers because they already know what their contract says. They negotiated it either individually or as part of a group, and almost all of them are really aware of what their rights are, as they should be. So they're not in the situation going to a lawyer asking, I think I'm about to be fired. It's people who are at will. Who are doing this. And the challenge is, if you, again, have the warning signs of the performance improvement plan, progressive discipline, which is where they've been just documenting over time that you continue not to do what they told you to, and performance reviews that are paperwork showing you did not perform well, then that's just all extra paperwork. So that if you think you have a case and you go to a lawyer, and the lawyer is going to always ask you, I do whenever I take these cases, which I haven't done in a long time, for my schedule and other reasons, that when there's a good case, here's what a lawyer wants to see. A good case is, hey, your performance reviews said you were awesome. There's no performance improvement plan. There's no progressive discipline. All your paperwork shows you're the greatest employee ever. And now they're going to fire you? That puts the company in trouble. That's the worst case scenario for an employer, because it can't be a situation where they're letting you go because of your performance, because their paperwork shows that you're awesome. That's the worst case scenario for an employer, and that's actually pretty common because of poor management, poor training, and a lack of understanding from the company perspective why it's such a big deal that they document and are consistent in their decision making. But that's a different issue, and that's why I do so much corporate training. So here we are. What do you do if you are about to be fired? You've confirmed you're an employee, right? The place where you work, controls the means and the methods of the job. You've confirmed that you're at will, all right? So you understand that your best only hope, basically, for some sort of situation is, assuming that there really isn't something illegal. I mean, there are situations. I've taken these cases where people are making decisions saying, I don't want women working here or whatever, and then firing somebody for that because of their gender. That's blatantly illegal. You have a great case then. I'll do some shows about how you handle those types of cases, what the EEOC is in the U.S., how you file a claim. But if you're about to be fired, shut up. Don't talk to any of your coworkers. They're not going to help you. Collect evidence, paperwork, the reviews, all those types of things, emails from your manager saying how great you were, and then you need to go to a lawyer before you're fired. Go to a lawyer now. Do not wait until you're fired because you're in a much weaker position. Thank you for joining me.